Welcome everybody. For the Michigan State fans in the group, congratulations for the and for the Michigan fans who came out tonight instead of sitting at home in front of your TV. Good luck. All right, Janine, please, or roll call.
Commissioner Amy Carroll, present. Commissioner and Trustee Mark Edwards. Here. Commissioner Jim Polkron. Present. Commissioner Janine Saputo, present. Commissioner Roger Schultz is absent.
Absent.
And notified. Commissioner Barb Wolek.
Present.
Commissioner and Chair Jim Carter.
Present.
Mr. Chairman, we have a quorum
Thank you.
here except for one. And with us tonight, we have Larry Nix, our township planner from William & Works of Grand Rapids. They got more snow than we did. And also Jim Creech, our township manager. Thank you. Our township supervisor is with us in the audience, Joan Fogel. Thank you.
Thank you. Next on the agenda is the approval of tonight's agenda. I'd like to suggest that we change the order of this agenda to do number 7 before number 6. Might move along more quickly that way. So I would suggest we do the Lost Lake. Are we okay with that?
I'll make a motion to change the agenda to move Lost Lake Nature Park Development number 7 in front of number 6, Blossom Ridge rezoning request.
Support.
All those in favor say aye.
Aye.
Opposed? Motion carries. Next is the approval of last month's minutes. I trust all of you have read the minutes from December 6th. And aside from the corrections noted, are there any additional corrections? Hearing none, is there a motion to approve the minutes as written?
So moved.
For support? Support. Motion made and supported. All those in favor say aye.
Aye.
Opposed? Motion carries.
Jim, one abstention. I wasn't there.
You can still vote on the minutes. We've already established that.
Yeah, no, I understand that.
Okay. Choosing to abstain anyhow. Thank you. Next on the agenda is public comment. This would be for items that are not on tonight's agenda. So if you are here for Blossom Ridge or Lost Lake, that would come later. But if you are here for anything else, now would be the time to speak. Is there anybody? Yes, sir.
Good evening, Mr. Chairman. Joe Langlois, 490 West Nile Road. I just have two general procedural questions I'd like to run by the Commission. First, in regards to the Open Meetings Act. The second, regarding the Planning Commission bylaws and rules of procedure. In regards to the Open Meetings Act, I haven't not done an exhaustive research of it, but I have reviewed the statute, legislative history, case law, and various Attorney General opinions. Certainly, the Open Meetings Act applies to the meetings of this Commission, as you're well aware. The Open Meetings Act does not distinguish between a public hearing and any other meeting. So whereas the bylaws of this Commission segregate or subset the public hearing, the statute does not. Any meeting is governed by, any meeting of a public body is governed by the Open Meetings Act, and that requires that all persons shall be permitted to address the meetings of the public body, in this case the Planning Commission. There's a specific Attorney General opinion that states that held that that limiting the time at a meeting in which citizens can address the public body to a half hour, which completely denies a person the right to address the public body, would constitute a violation of the Open Meetings Act. Upon reviewing the 2 to 3 hour tape of the December 6, 2011 Commission meeting, the Chairman and Commissioner Wallach restricted the public comment to 10 minutes, 3 minutes of which was taken up by the Chairman, so it left only 7 minutes for public comment, and there's certainly some people that wanted to make comments at that meeting that could not, and therefore, at least my opinion, appears that there was those restrictions that are violating the Open Meetings Act. Obviously, as you're aware, there's various repercussions for violation of the Act. In regards to the Planning Commission bylaws and rules of procedure, those require the chairman to read any correspondence submitted from the public at a public hearing. The minutes of the August 2nd, 11 public hearings state that the chairman read the comment of an email from a supporter of the project, but summarized the content of numerous emails apparently against the project. And my opinion, based on your own bylaws or the bylaws of this commission, those bylaws were violated. So my question is, again, I didn't do an extensive, exhaustive research of the various statutes and laws, but am I correct in my understanding of the Open Meetings Act as it applies to this commission and the bylaws and rules of procedure, or am I mistaken?
Mr. Langwell, you're an attorney, right?
Yes, I am.
Okay, I'm not an attorney. So you are in a better position to interpret the law as it appears to you. Whether you're right or not, or whether the township is right or not, would not be determined by you nor by me. Be determined, if it went that far, by a judge. Is that right? Do I understand how the process would work?
That's correct.
All right, it's my understanding that the Open Meetings Act requires us to conduct our business in public. We do. We do not meet outside of here in private. If we have to conduct township business, like looking at a project, we take the necessary efforts to make sure that none of us are there and forming a quorum, thus invoking the open meetings requirement to conduct our meeting in public. Furthermore, since you mentioned it under that point with regard to public comment, I think on this proposal we've entertained more public input than we have in any other proposal that we've considered since I've been on the Planning Commission. That may or may not be true. That's just what my gut tells me, is that we've entertained more. We were obligated to have a formal public hearing. We held that long ago. We're not obligated, in my understanding, to have additional public input, although we've welcomed it. Not only have we welcomed it at every meeting that we've had since this proposal was taken under consideration in August, this will be the 7th month, we've also welcomed it by way of written form, email and letters that have been sent and brought into the record. You may take issue with the way that we've chosen to bring them into the record. They've been brought into the record nonetheless. And if, I should say just the same. And furthermore, at the request of residents that represent a group of citizens, Citizens for Responsible Growth, I believe it's called. It's my opinion that that is not a recognizable entity by the Planning Commission. You may disagree. It may be recognizable by the state as an entity for tax purposes, so you can collect money and spend money on for whatever purpose it's intended. But it's my understanding that the party involved in this matter is the Blossom Ridge, on the Blossom Ridge proposal, is Mr. Mosheri and his team. It's the township's duty to consider this application. Each resident of the township may have an opinion. Many of you may have the same opinion. There could be 100 people in this room that all have the same opinion. Does not mean that everybody in the township has the same opinion, nor does it mean that they're recognized as a group. Nevertheless, the principles that have been put forth in various letters and various position papers and even in verbal discussions that I've had with a couple of the representatives from that group have made their way into our discussions, our consideration, and into the record, in written form, in verbal form, many, many times. You may take issue with the form and the function, but the result is the opinions have been brought in and taken into consideration. Would you not agree?
Yeah, my only encouragement, and certainly I'm not requesting that you follow my advice, but that I would encourage you to then consult with the township attorney to make sure. All my concern is that this body, the township trustees, is following the rule of law and the proper procedures. It's your bylaws, this commission's bylaws, that tells you what you have to do. And
you've taken issue with the manner in which we've conducted our business on this Blossom Ridge proposal.
Just 2 points. One is what I'm explaining to you is that, and I don't think for a minute that you intentionally violated the Open Meetings Act, but I think what I was making you aware of, I sensed, and that's why I did my own research, I sensed that you felt that this commission felt that that public comment was really only required at the public hearing. And what I was telling you is that that's not true. Each meeting, the public has the right to comment. That's.
If we felt that, why would we waste the time of the public or us on the commission or people who are paid to be here to take additional comment if we only felt it was required at the public hearing?
I don't know, that was my, well, because it was restricted to 10 minutes last meeting and about a half hour the meeting before, so that was...
And in most of the prior meetings, people have been allowed to speak for as long as anybody stood up. I would agree that maybe in the last meeting there wasn't enough time to allow everybody that wanted to speak, but let me put the question back to you another way, realizing we have a full agenda tonight. To what harm? Do you feel that there have been opinions and voices not heard by this commission?
Well, it's certainly, I think, I would say in general, you have allowed public comment looking at the minutes, but I think it's important that, obviously there's different issues that are rising with this. I don't live by the way, I don't live by this proposed project. So my goal is that the rule of law and the bylaws procedure be followed. So I don't know what the comment was going to be, but certainly there appeared to be at the last meeting people who wanted to make comments that were not allowed to. What those comments were going to be, I don't know. Obviously there's different issues that have come up. You've met on this topic a number of different times. So I'm not trying to be nitpicky. I guess I'm trying to make you aware, and certainly you consult with the township attorney, but I just want to make sure that you're aware of the laws as I see it. And yeah, I did feel that at least at the last meeting, and probably the last two meetings, that residents were not allowed to speak. And there should be, again, more time for them allowed to speak. That's my main point. So.
But the question I asked you that you didn't answer in all that was, do you feel that there was a comment that we missed, that you know, somebody wanted to make a comment about something that has not been said yet, for the record?
I don't know what the comments were going to be. I answered that question. I know Mr. Cerna, I believe, at the last meeting wanted to comment. I don't know what he was going to say, so I don't know what those comments were. But I do believe there was people that wanted to comment that weren't allowed to. So that's my point.
And that's not being nitpicky, is what you're saying?
No, I don't believe it's nitpicky at all. That's the rules. That's the law.
Gotcha.
Yeah.
Thanks.
Thank you.
Anybody else?
Yes.
Mr. Turner?
Chairman, I'd like to make a comment.
Not about Blossom Ridge.
Not about Blossom Ridge.
Thank you.
We want to follow the agenda. I'm Bob Cerna. I live at 5823 Wellwood Court. Been a resident of Oakland Township for 21 years. Esteemed members of the Planning Commission, over the last 5 months, we've heard discussions by this commission and reviewed letters from the Williams and works written by Larry Nix. These letters and your discussion seem to be contradictory, at least in one point. Mr. Nix's letter...
Mr. Cerna?
Yes, Chairman?
Isn't this about Blossom?
No, it is not. It is not about Blossom Ridge. Bear with me, Mr. Chairman. Mr. Nix's letters do not provide the Planning Commission with consistent and clear and accurate reading of the zoning PRRO statute. Understanding the statute is a core issue of your Commission's goals, and the main goal being a fair and considered review of any PPRO proposal that comes before you. The statute allows the applicant to propose, any applicant to propose a plan that is more strict and limiting than the rezoning of the underlying zoning law that he's using with the PRRO. But clearly in the law, on page 27.9 of the 400 pages in the zoning law, or 500, whatever they were that I read several times, approval is clearly based on comparing the existing zoning, underlying zoning.
Stop you there just for a minute, and let me explain why I'm stopping. I believe the letters that you're referring to from Mr. Nix are all with regard to the Blossom Ridge. My suggestion, and the reason...
Is it?
Mr. Turner, the reason I'm insisting that you wait is that if you want the comment considered as part of the discussion of Blossom Ridge, when we look through the minutes to see what was said at the last meeting, we don't... If we're looking for a Blossom Ridge comment, where do we look? Under the Blossom Ridge